Welcome to this episode of People's Law. I'm your host, Bob Cocco. I've been a practicing lawyer in Philadelphia for over 20 years. Most of that time I've specialized in consumer protection law. That's an area of law that is not very well known to the general public, like, for example, personal injury law. So my goal in this show is to improve the average person's basic knowledge of the laws that most affect their daily life, but which they may not be aware of or just need to understand better. To do so, I'll have guests from the legal community provide you with useful information, hopefully, to protect your legal rights in different areas of civil and criminal law. In our show today, we will be discussing two legal topics. The first involves civil law governing the use of background checks to hire potential employees or fire existing employees. And the second interrelated topic involves a criminal law issue, and that's understanding how to change a person's criminal record history using pardons, expungement, and commutations. To help us understand and discuss use of background checks in employment, we'll hear from labor lawyer, attorney Ryan Hancock. So let's introduce our first guest. Ryan, welcome to the show.
Thank you for having me.
Ryan, let's start out with some basic information about you. How long have you been a lawyer?
Sure. I've been a lawyer for about 14 years. I'm now a partner at the law firm of Willig, Williams & Davidson, but prior to that, I was Assistant Chief Counsel with the Pennsylvania Human Relations Commission, which is the state's or the Commonwealth's civil rights agency.
And is the Willig, Williams & Davidson firm dedicated to any area of law?
Absolutely. We only represent employees and union members and their families. That's correct.
So let's talk about something that I think you've had a lot of experience with, and that is background checks in the context of employment and the context of employment litigation. So let's start out with the basics. What is a background check? Although a lot of people have heard about them, let's talk about what exactly they are, at least in a broad sense.
Sure, in a broad sense, it's also known as a consumer report, right? So that people conflate the two, consumer report or a criminal background check. But under Pennsylvania law, a criminal background check is the information with regard to an individual's arrest and conviction record. Okay, and it goes a little bit deeper in Philadelphia, or I should say in Pennsylvania, because everybody's criminal record is available online through the UJS portal, right, which is the court's website. And anybody, including your neighbor, can look you up and see your entire criminal history, even if it doesn't lead to a conviction on that website. But technically, your criminal background check for employment purposes should come from the Pennsylvania State Police, which is the official repository of the criminal background information in Pennsylvania.
Okay, so we will focus probably mostly on criminal history here today, but a background check for everyone's information can include more than your criminal history record information, correct?
That's absolutely correct. It could be your credit information, it could be other information about where you've lived, what you've bought, it could be a whole host of things. In fact, what defines that usually is called the Fair Credit Reporting Act, which we'll discuss a little bit more in the context of criminal records. Okay.
So let's talk about what's required under the Fair Credit Reporting Act before we get to Pennsylvania laws. If an employer pulls a background check for a job applicant, what's the procedure that they have to follow? So let's start, for example, first. Do they have to get any kind of authorization from the prospective job applicant to pull the check?
Yes, absolutely. So there are a couple of three broad strokes when we're looking at what the Fair Credit Reporting Act, or FCRA, is what we call it, right, as practitioners. But there's three sort of large pieces of information, buckets that have to happen with regard to the Fair Credit Reporting Act. One is the authorization, right? And part of that authorization should be a standalone. It should be a piece of paper that gives the FCRA rights along with your ability of why you're giving this information, what you're signing off to. So that's one piece. As far as the second piece, which is called a pre-adverse action letter, right? So if the employer decides to deny you employment in whole or in part because of that criminal record, it has to do a couple of very technical, substantive things. It has to, before it makes that determination, give you a copy of your background check that it was relying on, and two, let you know that they may take an adverse action prior to them actually making that adverse action. So in other words, they have to give you a copy of the background check. They have to give you a reasonable amount of time to be able to respond to that criminal background check before they can make the final hiring decision.
Right, and the reason for giving you time to review it is, it's true, is it not, that there's commonly errors in these background checks?
Absolutely, of course. So not only are there errors, which is really what we see all day, every day, right? So like, for example, the individual job applicant's date of birth is incorrect, so they got the wrong person. The fingerprints might be incorrect. They don't live, right? They have different name matches. These are some of the easy things that you can see on a criminal background check. I mean, I have clients that don't have a criminal record at all, and all of a sudden have a 7-page criminal record, and they're being denied a job because of that. But as the Third Circuit recently just said, right, which is our appellate court, it's not just about correcting incorrect information, but it's about the opportunity of the individual, right, to be able to tell the employer, in this case, why they should still be hired even though they have truthful, correct criminal background information, right? Because it might not be substantially related to the job, or some other information. It might be stale, it might be old. So that whole purpose of the Fair Credit Reporting Act is not just the correction of it, but it's to give the job applicant an opportunity to tell the employer why they should still be hired.
So let's segue into that area of where there's a criminal background that is accurate. I know from talking to potential clients that some people have are resigned to the fact, they're seemingly resigned to the fact that I have a criminal record, so I know I can't get a job without them asking me about it, right? But for example, in an application, can an employer ask you in an application if you have a criminal background?
Right, so that's a good question, and it really depends on a myriad of different where you are, state law, where you are in a city. So for example, in Philadelphia, you're correct. Philadelphia had passed in 2015 and came into effect in 2016. What is colloquially known as ban the box, right? So in Philadelphia, a job application cannot include information about arrests not leading to convictions. And they can't really ask that until a conditional offer of employment. So in Philadelphia, no, they can't ask about that on the application. However, you go outside of Philadelphia, an employer may be, depending on the municipality you're in, be able to still ask that. In fact, I believe only Philadelphia in Pennsylvania has banned the box.
And under ban the box, they can ask about criminal record information for only a limited period of time too, correct?
That's correct, up to 7 years.
Under the Fair Credit Reporting Act, if it's a conviction.
Yeah, you bring up a great question, because a lot of people have this misunderstanding. You often hear my clients come to me and they say, well, I haven't had a record in 10 or 15 years. I didn't think that they could go back that far. Well, under the Fair Credit Reporting Act. Well, the truth of the matter is that they can, right? The Fair Credit Reporting Act doesn't say how far back an employer can or cannot go.
So in addition to the Fair Credit Reporting Act, we talked about ban the box, there's another state law that controls how an employer can use your criminal record information, correct?
Right, that's called the Pennsylvania Criminal History Record Information Act. And it's a really interesting statute. Most people know this statute based upon the expungement or the sealing, because that's really where the power of the Commonwealth to eradicate records comes from. But in that provision, Section 9125 lays out how employers can use criminal records in Pennsylvania. And in fact, the state law specifically says that employers may use criminal records, but they can only use certain criminal records, right? And those are, they can only misdemeanor and felony convictions can only be used if it's substantially related to the job.
And what are some of the criteria that the courts have interpreted or that otherwise exist that helps a court interpret whether or not a job duty is reasonably related to a criminal conviction?
Yeah, I mean, that's a really good question. There's not much case law in Pennsylvania. In fact, we've been trying to build that for quite some time, but you know, a good case usually settles. So, you know, when an employer sees when they have violated that statute, which they may not have known about, they generally try to settle that. But what we would look to is generally the factors, for example, of the EEOC or the PHRC, which are both the state and federal civil rights agencies, what they look at.
Yeah, what do they look at? Age of the conviction?
Yeah, absolutely. They look at the age of conviction, what was the actual conviction, how many times they were arrested, what has the applicant done since the arrest or conviction, right? So they're kind of looking. In other words, the best way I can put it is using common sense and the ability to look at someone on an individualized basis, right? Looking at the job that they're applying for, look at their qualifications, and determining whether that is important.
Okay, and we'll pick it up further with Ryan and talk a little bit more about how to combat a bad criminal record. So we're going to take a short break, and when we return, we're going to talk more to Ryan about the criminal records and expungements and pardons, as well as commutations. So we'll be right back.
According to the Mayo Clinic, exercising has stress-busting benefits by bumping up your endorphins and improving your mood.
Welcome back to People's Law. I'm your host, Bob Cocco. To help us understand and discuss the use of pardons, expungement, and commutations, we'll hear from labor lawyer Ryan Hancock once again. But before we get to that topic, I want to follow through with some final issues on civil litigation involving background checks in the context of employment. So one thing we didn't discuss is what damages are available to a job applicant who feels they've been a victim of unlawful use of a background check. So what are some damages available to them?
Yeah, so that's a great question. I mean, it also depends on the statute in which you're bringing in.
We've discussed several. Right?
You know, we've discussed the Fair Credit Reporting Act. We've talked about the Criminal History Record Information Act. We've talked about the Fair Practices Ordinance, which is Philadelphia's colloquially known as the ban the box. We also didn't talk about, but which is something that's important, is that individuals, specifically in protected classes such as race, right, could have a claim for the use of criminal records and applications, disparate impact claims, both under Title VII and the PHRA. Now, in general, the damages are quite similar, okay? So generally it could be your back pay, for example, if you weren't hired. It can be your statutory damages, whether it's the Fair Credit Reporting Act or the statutory damages under the Criminal History Record Information Act. All of these statutes are also fee-shifting statutes, which basically means that if you're successful, the the attorney fee provision shifts, and you could recover your attorney's fees as well. And certain other smaller things like changes in the law, policy changes, injunctive relief, which is stopping the employer from using some sort of discriminatory or illegal job application process with criminal records.
Okay, so to make sure everyone understands, they can effectively, practically be represented for free if they find themselves a victim of a breach of any of these laws by an employer or the screening company that the employer hires.
That's right. It's usually called a contingency fee basis, and that's exactly right. A lawyer would generally represent somebody, especially in the Criminal History Record Information Act world, for free, and which means that they basically won't recover unless they recover for you, right? And that's a good part of the fee shifting piece, statutory provision.
Okay, so let's move outside of the framework of litigation and talk about what a person can do to fix a criminal history record, regardless of whether it's the subject of an employment action. So let's start once again with definitions. I know from talking again to potential clients that expungement is something that people understand in different ways, and that they understand it to embrace what is a pardon. So let's talk about what those terms really mean. Let's start with the expungement.
Yeah, and I think it's actually really important to step back, because I think what's really important about this conversation that we're having is that all job applicants should actually look to know what their criminal record is, right? And so, as I talked about before, is that an individual can go to the UJS portal, which is the Pennsylvania Court's website, and look and pull up their criminal record. Now, that's not the official repository, but it will tell you what you've been arrested for or convicted for. And then you look at that, and then so you can determine whether you need an expungement, a pardon, or a commutation of your parole, for example.
So let's discuss what each of those terms means. Yeah.
So expungement means basically the eradication of that record. And what's interesting in what you were talking about, the difference between pardon, is generally under Pennsylvania law, what can be expunged is generally non-conviction information. Okay, so that means that you were arrested but not convicted. Now, there's some exceptions to that rule, right, that you see. Like, for example, summary convictions can be expunged, okay? Or if you've entered into some accelerated rehabilitation disposition program, right, like drug court or something like that, if you successfully complete those can be expunged. But generally, you can't get anything expunged that's been a conviction.
Right.
Now, under Pennsylvania law, the statute has been amended to include this thing called sealing, which has allowed certain convictions to be hidden from public view, which is different from expungement, because expungement is the destruction of that record, where sealing is just hiding it.
Okay. So how about pardon then? So pardon comes into play if you have an existing conviction.
Yeah.
And you want to have that erased.
That's right, and I'll step back a little bit, because I think it's really interesting under the expungement statute. So I wasn't exactly correct, right, in the sense that you can expunge conviction records under certain conditions, which are really funny. You're 70 years old and you've been crime-free. If you've lived that long, you can get your convictions expunged. Or if you've been dead and wait 3 years, you can also get an expungement of your conviction records. But generally, if you want your conviction records to be destroyed, if you wanted to be restored and as if you've never had a conviction, that is the pardon process. And that pardon process is a relatively long process, but it's worth it, because it's a reinstatement of your rights in recognition of the Commonwealth that you have completed your sentence, you've done well in the community, and you deserve another second chance.
So let's talk about two aspects of pardons. So number one, unlike what we were discussing before in the employment context, if you want to hire a lawyer to secure a pardon for you, you will have to pay them for that, correct?
So that's a good question. So when you're looking at expungement, for example, there are lots of legal aid organizations that do free expungements. One of the organizations that I started, named the Philadelphia Lawyers for Social Equity, we hold 2 to 4 expungement clinics in the communities most affected by criminal records and represent thousands of people for free. Community Legal Services does the same.
So if they're income eligible, they can...
If they're income eligible, right? And income eligible means how much money you make and your family makes in general terms. And for our purposes, or for the Philadelphia Lawyers for Social Equity's purposes, it's about 200% over the poverty line. With regard to pardons, generally you do have to hire a lawyer, but again, the Philadelphia Lawyers for Social Equity will also represent people for free during the pardon process. Now, the pardon process is kind of interesting because you don't actually need a lawyer, and in fact, the pardon board, looks down upon you having a lawyer, right? What the pardon board wants you to do is come in, admit that you did what you did, and show all of the good things that you've done in your life for them to give you a second chance.
And they're located in Harrisburg, correct?
That's correct. So actually hiring a lawyer is maybe not the best use of your money, but it can be. And the reason why, they could walk you through the different processes to get a pardon, because the application is pretty significant.
Okay, yeah, and the other thing I wanted to mention just briefly, because I had a potential client discuss it with me, they were under the impression that a pardon was something you have to secure the governor's approval for, or a senator, or something like that. But it's actually a much more humble process.
Well, it's somewhat of a humble process. I mean,
Yeah.
they're right in the sense that the governor has to ultimately sign off on it, but it's the pardon board who makes the determination. And generally, if the pardon board says yes, the governor generally signs off on that pardon.
Right, so it's only if it's very controversial that it's going to get that kind of
That's correct.
review by a higher
unlike,
official.
That's right, and unlike expungement, remember, anything can be pardoned. So any crime, right, any crime of violence, et cetera, can be pardoned. Doesn't mean it will be, but I'm just saying under the statute, there's no limitation of what can be pardoned by the pardon board.
So let's talk finally about the third item that I mentioned initially, which is commutation of a sentence, or
Right.
let's discuss what that is.
Yeah,
basically.
so a commutation is, for easy purposes, is asking the Commonwealth to lessen your parole sentence, or if you're, for example, serving life, would be a commutation of life. But most people see it in the tradition of probation or parole, right? Commutations in the state system, local system also has probation. So it's asking the court to reduce your parole or probation requirements.
And once again, is that something that an individual can do on their own by filling out an application, or is it best to secure counsel to seek a commutation?
For that, I mean, listen, of course, you can also always file something pro se in the court. For something like expungement, and in particular commutation or probation, asking the court to reduce that probation, I think it's always good to have a lawyer. You don't need one, but I think it's good because they know the process and can hustle it through in a probably much more easier way.
So there's another issue I wanted to discuss in connection with all three of them, and I have to look at my card here because I want to make sure I get it right because I'm not familiar with it from my own experience. The concept of collateral consequences when the district attorney or assistant district attorney is looking at any of these options that are brought to them or pardon board. What would that be?
Yeah, so collateral consequences are civil penalties that are attached to criminal penalties, right? So they're separate, right? We have a criminal and a civil system. So a judge generally, a criminal judge is, well, first of all, let's step back and say that a vast majority of convictions are created by plea agreements. I mean, we're talking about 96 to 98%, whether it's in the state or federal system, of convictions end in a plea agreement. So when a judge is looking to plea someone out and looking at the penalty, they're just looking at the criminal penalties, right? They're not looking at the civil penalties that may follow those criminal penalties. And those are colloquially known as collateral consequences. And in Pennsylvania alone, there are 800 plus different collateral consequences attached to those criminal penalties. Collateral consequences can be, for example, denying an individual from a job, denying someone from housing, from a licensing opportunity. There are all kinds of different statutes that limit the rights of individuals with certain convictions, and that's colloquially known as a collateral consequence.
So how does one attack a collateral consequence? Is that part of a pardon or an expungement or commutation process, or is that a separate process?
No, I like to think of them as all the same. I mean, I think that's why a job applicant has to actually do that in advance. I think you have to know what your record is. I think that you have to take proactive opportunities to try to clear your record, either expungement, pardon, or a commutation process. And then know your rights about collateral consequences, right? So know your employment rights, know your housing rights, know your licensing rights, et cetera. And that will lead you to the ability to live a much more whole and productive life.
Well, we've covered a lot of ground. Do you have any final thoughts on any of these issues that you think we haven't covered so far?
No, but I would say that if anybody has been denied a job because of their criminal record, they're free to contact me at any time, and I'm happy to give a free consultation and discuss their matter with them. So
why don't you tell the listening audience how to get in contact with you?
Sure. You can contact me at Willig Williams & Davidson. My direct phone number is 215-656-3679, or you can email me at rhancock@wwdlaw.com.
Okay. Well, thanks, Brian, for coming on the show. And thank you for all the useful information you've given. So if you're interested in discussing or learning about the topics we covered today, you can go to my website where these videos will appear, phillyconsumerlaw.com, or of course you could contact any of our guests at the information they provide to you. So I'd like to thank our guests for joining us today. I also would like to thank the viewers for tuning in and watching. So until next time, remember, take the time to understand and protect your legal rights.